Does anybody have, if you have a specific question, you're welcome to just raise your hand, and then we have probably, how are you able to stay till past?
Yeah, absolutely.
Okay, cool. So we have about 15 minutes, and maybe we can do questions for like 13 of those, and then we can wrap up. Cool. So the one thing I will say about questions is just try to keep them more general rather than case specific, so that we don't get bogged down in any one case for the entire time that we are able to ask questions. And also because, as both our speakers have said, it can take significant research to actually be able to answer more specific questions. So yes. Okay. Imogen and then Valerie, please.
Hello, mine's a very general one. It's about the relationship between the freeholders and the landlords in terms of you as a tenant. A lot of these market sites are partly or all on public land. So be they local authority, Transport for London, or National Rail, whatever, they're the freehold of quite a chunk of these markets are on this public land. And what I'm interested in is, how can we get the public bodies to advocate for us? Do they have any voice legally in these sort of negotiations? I know there are some things to do with the consultation, but how do we get them to be more on our side? I suppose it's a slightly political question, but it's also about the legal angle of it. Thank you.
Definitely. So maybe if I have a go first and then hand over to Harley. If they are the freeholder, the public body, then they are entitled to be on your side if they want to be, and they're subject to specific duties because they're public bodies, which include the duty not to discriminate and to have due regard to the quality impacts of their decisions, and they can be taken to court, judicially reviewed in a way that private landlords can't be. But all gets a bit complicated where that they may be the ultimate freeholder, but they've given most of their rights over to a commercial leaseholder who's like the top leaseholder, but then all the subleases follow down from that. Again, it's hard to give very specific advice about knowing the particular circumstances of it, but to the extent that they have any rights that can be exercised in your favour, then according to the terms of the lease that they've granted to someone else, then they should be able to exercise those rights, and there's nothing to stop you lobbying them, speaking to them to trying to get them to be a bit more on your side.
Yeah, I agree with all of that. Just to add, really, that unfortunately, though, in a lot of contexts, local authorities don't want anything to do with it because they granted the lease to someone, and they just their attitude often in practice is, well, we've granted the lease to so and so company, and they're entitled to do what they want to do. But I agree with everything Alex says in terms of your actual or the earlier part of the question about the relationship between you and the freeholder. So in theory, you don't really have anything to do with the freeholder at all, because your landlord is the person under your lease. So let's say it's a company, a redevelopment company or something. That's your landlord, and your relationship is governed by your lease with your landlord. So unless the contract or the lease between the freeholder and your landlord specifically requires the freeholder to be involved in certain ways, or perhaps even has them as a party to the lease, generally the legal position is going to be that the freeholder simply isn't involved in these type of things as a matter of contract law or landlord and tenant law.
Valerie, would you like to go next?
Hello. Thank you so much. This has been a lot of information. I have two questions. One is, how are traders able to hold landlords accountable for verbal agreements? We've had the situation many times where either with like independent landlords or like management companies make promises to them, is all informal conversations, and then they just act like the conversation basically never happened. So is there a way for traders to yeah, hold them accountable for those conversations? And then on the last slide, I don't remember how it was called, but it was something mentioned about persuasion and intimidation. How are maybe traders able to prove that intimidation has been happening, I guess, in terms of the relationship with the landlords? Thank you.
Thanks, Valerie. And perhaps I can start with this one again. So it's all about evidence in terms of, what's agreed and what wasn't. Ideally, you'd have something written down, but which is signed by both sides in a contract. But if not, if you've agreed something with your landlord, then ideally on the day, go home and write it down and date it. So you can say, I spoke to so and so, they said X, Y, and Z. And then even better, you can send your landlord an email saying, here's a note of our conversation earlier today. If the landlord may well just ignore that and not say anything, but when it comes to a dispute later on, a year down the line, 6 months, 2 years, you can say, well, look, I sent you this note of what was agreed, and you didn't say anything back in response. And so if it ever comes to court where you have to, work out what exactly was agreed, that's pretty strong evidence. If you've got it's got a contemporaneous note, and note at the time, and they haven't disputed it either at the time when you sent it over to them. So that's a good way of doing that. Similarly with harassment and discrimination, anything like that, just keep a log. I would a diary effectively, dated. So you've got a record of incidents, because it's much easier being able to go back when you're looking at this later, when you're bringing a complaint, etc., to have a written record of stuff that happened at the time rather than trying to remember previously. He said something like that to me a while back, but I can't remember exactly what day it was. Also, message other people, tell them about it too. So again, if the landlord says, well, I never said that, she's lying, then at least you can say, well, here's the evidence that I spoke to 2 or 3 other people about it too. And if it's going to be a big important meeting with your landlord, to try and get someone, same for the first point, really, try and get someone else there in the room too, and get them to make a note too. Just so again, it's not just your word against the landlords. There's sort of 2 or 3 against one, and you're saying the same thing with a contemporaneous note.
I completely agree with all that, and I would just add to that in terms of how you go about actually relying on those facts and that evidence to have any kind of legal effect. There is various mechanisms in the law, in landlord and tenant law, by which you can rely on a landlord's conduct or assurances in respect of your obligations under the lease. So one route is what's known as estoppel, and the idea is it's a concept developed by the court to say, well, if you make an assurance to someone, make a promise to someone, that promise is relied upon to that person's detriment, and it would be unconscionable for that person to then renege on that promise. The court would enforce that promise, even though it might not have complied with the formal legal requirements as to properly varying the agreement. The promise by the landlord could actually have the effect of varying the agreement if an agreement that doesn't need to be. It could have the effect of surrendering the original tenancy and creating a new tenancy subject to those revised terms. So there's actually quite a lot of ways you can translate those facts into what's known to the law as a kind of cause of action, a claim. As to actually how you force the issue, though, let's say you do have a dispute. Let's say your landlord says to you, I'll vary the rent for the next 2 months to £500, and that's a reduction. And then they come along and demand the full rent. Well, it's really never advisable to withhold rent from a landlord because it usually gives rise to the right to forfeit. But that's an example of how you might force the issue. You might withhold rent. Landlord then needs to sue you. You can counterclaim for a declaration. We talked about declarations that actually the rights have been varied or there's an estoppel. You could also bring your own claim for declaratory relief, for an injunction if the landlord's threatening to do or not do something. So yeah, Alex is absolutely right in terms of how you evidence it all. And then in terms of actually how you do anything about it, there are lots of ways. One of them is estoppel, one of them is thinking about variation, and one of them is thinking about has the effect of this been to create a new tenancy. But again, I'm afraid it's very fact specific in every case.
Thank you. Susanna, would you like to go?
Yes. Hi, thank you. We are actually dialing in from the Boundary Community Laundrette. Two and a half related questions. The first question would be, does the landlord need to prove that the Section 25 notice is correctly served or properly served? Because no one actually received that.
Yes, yes is the answer to that. Sorry, yes is the answer to that one before you went into the new question. Service in law just means to bring a document to someone's attention, and unless the tenancy agreement says something about service, and it's quite a complicated idea, but the idea is that a provision in a tenancy agreement might say a notice is deemed to be served even if it doesn't come to your attention. That might scupper you. But generally, yes, the landlord needs to prove it's been actually received. Sorry, that's just to separate that out from your second question.
Great, thank you. If the landlord has since, due to pressure from the campaign, returned the keys, and we have continued to be paying rent every month as per what they deem as the old lease, but currently we are in this situation where we have no lease. If we accept what they say is that from January 2024, your old lease is terminated. So what it means is that we are sitting there conducting the business, paying them the rent, which they're accepting, paying them service charges, everything as per the old lease. But currently, if they try to serve a tenancy at will, should we just not kind of challenge that?
Yeah, that sounds possibly a bit too specific, but
yes.
I think I for my part, I'm happy to talk about that outside of this meeting if you speak to.
Yeah, we're in touch. We're in touch, Susanna. So I'll hook you up. Right?
Yeah,
Great. Thank you very much. Thank you.
Just because it's sorry, Suzanne, not just to be boring, just because of the way we're regulated, we have to be instructed by a solicitor before we give advice. Okay. But for my part, I'd be happy to give you some more specific advice, but it would need to be, we need to do it properly, basically.
Right. Okay. Thank you very much.
Contact Saskia and we can go from there.
Yes. Thank you.
Okay, great. James, would you like to go?
Evening. First of all, again, this might be a little bit too specific, but if there's a number of tenants who were outside, excluded from the Act 1954, and their lease has come to the end of their period, but remained in their premises, not just for months, but for years, then is there an argument that these tenants may begin to become entitled to inclusion within the 54 Act, or at least have better business rights because they've been holding over in a premise out and being outside of the Act?
Yeah. Is that can I answer that one first if you've got more than one, because
Sure.
that's quite specific. So just so I've understood correctly, you're saying you've got in a general situation where you've got tenants not protected by the 54 Act,
Correct.
leases come to an end, they're holding over for a significant period of time. Does that kind of entitle them to any protection under the 54 Act?
Yes.
I'm afraid the answer to that is no, because if they're not within the ambit of the Act, either because it's been excluded or because they don't meet the statutory requirements, it's game over in respect of applying the Act. But what might have happened if they've been holding over for a significant period of time, I think Alex may have touched on this, so they may actually have agreed a new tenancy by implication, and they actually have what's known as a periodic tenancy, and a periodic tenancy is capable of being protected by the 54 Act. So you may actually have a situation in which that holding over has become converted into a new tenancy, and that new tenancy might be protected. So that, I think that's a thing to look at in that case.
Yes.
So definitely worth looking into. And Harley, you were saying as well, you can fall in and out of it, can't you?
Yeah.
Sorry, just a quick point of clarification for that. How long, if it's been held over, like how long would it have to get to before that conversion?
Happily or unhappily with landlord and tenant law, it just depends on the case. So the idea with a periodic tenancy is that it reflects intention. So if there's been a significant period of time, rent has changed, things like that since the term ended, then arguably the intention that the parties have is that they wanted to enter into a new tenancy. So it's not, there's no kind of hard and fast rules. It's all about intention.
Okay.
Intention as inferred from the facts.
Okay.
The
Yeah.
The second question that I've got actually out of three questions. The second question is, if a tenant is wishing to negotiate a new lease, do the terms of the current lease set an argument of precedence, in as much as that?
Yeah, there's a presumption that the current lease reflects what the new lease should be.
It does.
Yeah.
So if there are massive deviations from the existing lease to the proposal lease, could that be construed as unreasonable?
Not necessarily unreasonable. It's just a presumption. It's just a presumption that the new lease should be on the same terms. But really, you just need to make the argument in a case where a tenant generally, and I'm just talking in the abstract, where a tenant is having this kind of argument, they'll just need to have a good argument as to why the terms should be what they say they should be.
Sure.
It's nothing more than a presumption.
And my third and final question was, if somebody has a lease for their premises and they have that right of quiet enjoyment, then if there is a development which is going on their doorstep, then ultimately they can argue that perhaps their quiet enjoyment or their use of their premises is being compromised. In actual physical terms, how would you go about presenting a complaint about that?
Yeah, I mean, what in terms of how might a tenant actually? Do you mean practically how might a tenant do something?
Yes.
In the first instance, I think you would have right to, a tenant wouldn't be expected to write to the landlord, but there's no formal requirements here. You know, you can if a tenant wanted to write to the landlord and say, there's X and Y happening, that's a substantial interference with my rights of possession, quiet enjoyment, whatever. You know, it can be these things can be framed as pre-action letters. You know, if you don't do this, the tenant's going to consider, you know, proceedings or whatever. But in practical terms, there's no real procedure you need to follow for tenants, save that in any party to civil proceedings, there is an expectation by the court that you have tried to resolve it before you bring a claim. So in practice, you are often expected to try and resolve it by raising it through correspondence or speaking with the person in question. But sorry, that's probably not that helpful. But I mean, there just isn't really a formal route you necessarily have to go. But in what I would expect to see would be a kind of a letter, or if not a pre-action letter. But I don't know if Alex has anything to add to that.
Yeah, well, so as we've been discussing, important to evidence it as well, particularly if there's a factual dispute about what's actually happening and how loud something is or how much of an interference it is. So take as many photos as you can. There's a software function where you can date stamp them, so you know when the photo has been taken. If there's a video of disruption, you can take it as well, and again, time it as well. Say exactly when that video was taken. When it comes to noise, and we get this in nuisance cases sometimes as well, there are tools that you could buy online which allow you to measure the extent of noise as well. I mean, ideally, of course, if you had all the money in the world, you'd go get an expert to measure it, but you could probably do your own sort of the guerrilla job of it by measuring the decibels if it's a noise interference as well. But if you're going to bring a legal claim, you need evidence to back it up. So just collect all the evidence you can now, even if there's any chance you might have to bring a legal claim in the future, just because it's all fuel for the fire.
Thank you very much.
Thank you. So Bill, maybe you want to do the last question. I know you had your hand up earlier before you got knocked out.
Okay, can you hear me?
Yes, yeah.
Okay, the question I have is this. You mentioned early on that market stall holders could have a tenancy. In Hackney, where I work, and many other local authorities, their right to run a market stall is licensed under the 1990 Act. So what they pay is a license fee and charge. They don't pay rent as such. So I'm wondering on what basis you could argue that a stallholder in fact has a tenancy protected under the 54 Act.
Off the top of my head, I don't know the answer to that question. Harley, you may have some thoughts, but
yeah, I don't know the answer. What comes to mind in a kind of situation in which, because we can only really talk about the abstract or the general, if you've got a situation in which occupation is pursuant to or purportedly pursuant to a statutory scheme, and rent is paid purportedly pursuant to, or a fee is paid pursuant to a license, as we mentioned a moment ago, the imposition or the implication of a tenancy generally reflects intention. And I think what came to mind when you were speaking is that seems to me to potentially be tension between parties purportedly doing one thing expressly and then the law impliedly imposing a tenancy on the other. And I just wonder to what extent in that situation they're inconsistent, essentially. You know, if you've got parties doing one thing for one reason, to what extent is there scope for the law to come in and say, well, actually, we're going to infer from this arrangement that you actually intended a tenancy and that tenancy is protected. I'm afraid, yeah, that's a difficult question, which I also don't know the answer to. But that's what came to mind when you were speaking.
So it might be one for the Supreme Court then.
Yeah.
Well, I mean, I was just going to say that one of the characteristics of a tenancy is payment of rent. So even if you've got a fixed position in your market stall, you you're not paying rent. You're paying a license fee to the regulating authority, the local authority under the Act, under the 1990 Act. I don't see how you could have a tenancy. Whereas you might have a tenancy if you've got a stall in a covered market, say a little retail unit in a covered market, that might be a different scenario. But even then, their local authorities are saying you're going to pay a license fee for it, not rent.
Yeah, it's tricky because I mean you need consideration, don't you? But you don't always need to pay rent to get a tenancy. There's some circumstances where you can still have a tenancy even without paying rent. So it's still possible. But anyway, it sounds like quite a knotty situation, legally speaking. So probably not worth giving off the cuff advice on it, but definitely worth exploring.
Thank you.